All rise. The Court of Appeals, Division 1, is now in session.
Thank you. You may be seated. We're here today in the case Legacy Foundation Action Fund versus Citizens Clean Elections Commission. Our case number CV150455. As I mentioned during the last argument, we're joined today by former Chief Justice Rebecca Birch. We're pleased to have her filling in due to one of the vacancies on the court. These proceedings are being video and audio recorded, so please identify yourself and your client when you approach the podium. Each side will have 20 minutes. Appellant will be responsible for reserving any time you'd like for rebuttal. We have conferenced this matter. We've read the briefs and considered the record. And with that, we look forward to your argument.
Your Honor, Jason Torchinsky of Holtzman, Vogel, Josefiak, and Torchinsky for Appellant Legacy Foundation Action Fund. We're here today because the district court dismissed this case without addressing our jurisdictional challenges. The Clean Elections Commission, we have maintained from the beginning, has no jurisdiction over this case and exceeded its statutory authority. Fundamentally, independent expenditure reporting obligations have resided with the Secretary of State since at least 5 years before the Clean Elections Commission was even created. And in this case, the Secretary of State's office determined that the speech in question was not express advocacy in the first place. The Citizen Clean Elections Commission, however, reached a contrary conclusion. The independent expenditure definition resides in Title I of the Arizona Election Code, not in Title II, which is the only title of the Election Code by which the Clean Elections Commission is empowered to act. And additionally, at the time the Legacy Foundation Action Fund spoke in the spring of 2014, the definition of independent expenditure in this state had been declared unconstitutional by the Superior Court in Maricopa County. No stay of that decision had been sought, and it wasn't until during the pendency of this action that the Supreme Court reversed and actually upheld the definition of express advocacy. Additionally, Legacy Foundation is not a candidate or committee participating in the public funding scheme administered by the Citizen Clean Elections Commission. The lower court erred by dismissing this case on the grounds of 16-957B and didn't rule or failed to rule on our objections to jurisdiction. In other words, the concept that judgments that are void ab initio. This is a long-standing concept in the law, and the Arizona law has recognized this concept for approaching 100 years. I found a decision as far back as 1929 acknowledging the fact that judgments that are void and can be attacked at any time.
And doesn't that mean they can be attacked any time?
Collaterally?
Well, and you could attack it even if you didn't raise it below. You could raise it on appeal.
That's correct. And
that means you can raise it on appeal if you don't timely appeal. Isn't that a different question?
Well, that's a good question, but I think I would quote what the Arizona Supreme Court said in the Wells case, which said, quote, "It has always been held that the mere lapse of time is no bar to an attack on a void judgment."
How do you distinguish this case from the David Brunel Smith case?
The Smith case was very different because in the Smith case, for a couple of reasons, we don't believe it's applicable or controlling. In the Smith case, the candidate there had some constitutional and other objections to the Citizen Clean Elections Commission's order issued pursuant to 16-957B. In this case, there was no jurisdictional challenge alleged or asserted, and the Supreme Court in that case—
But he wanted to appeal, and he didn't timely appeal. How is that different from what we have here?
It's different from what we have here because of the notion that there is no lapse of time or other mistake that can make a judgment that is void from the beginning permanent and enforceable by a mere lapse of time. And I would point you to—
Well, we've often held, haven't we, that appeals that aren't timely filed, the court lacks jurisdiction to hear them. Is that a novel concept?
No, that is not a novel concept, but it's also not a novel concept that judgments that are void ab initio can be challenged at any time in any way. Either directly or
Are you saying that
collateral.
not even the 35-day time limit that you proffered, it was the appropriate deadline for filing an appeal? You could file it any time, a year later, 2 years later?
Yes, Your Honor. I think when you're challenging the jurisdiction, it's very clear that challenges to jurisdiction when the allegation is that the decision was void ab initio, there's no time limit that applies. And I point you to Wells, the cases that preceded Wells, the cases that cited Wells, including the Arcules case and including this court's decision from Pawn 1 from earlier this year. And I also point you to the fact that
What if you raise that challenge, though, in the court below and it's rejected? Don't you have an obligation to appeal from that ruling? It seems like you're hypothesizing a situation where no one has ever brought up jurisdiction, and you've now figured out that the court acted outside its authority. But that issue was raised below, and it came out contrary to your client's
the
position.
district court
Don't you have to appeal that?
The district court didn't rule on it. The district court dismissed pursuant to 957B and ignored our 12-902B argument that said, the sentence there says, if under the terms of the law governing procedure before an agency becomes final because of a failure to file a document, the decision is not subject to judicial review under this article, except for the purpose of questioning the jurisdiction of the administrative agency over the person or subject matter.
But this one didn't become final because of a failure to file a document. This one was rejected essentially on the merits.
Well,
isn't that right?
No. I think the argument is that it became final because of a failure to file a notice, which is a document. And I think where the Clean Elections Commission sort of goes off base is they try to take the phrase for administrative review in the second sentence of 12-902B and apply it backwards to the other provisions. It says, because of failure to file any document in the nature of an objection, protest, petition for hearing, or application for administrative review. I think a notice of appeal and an objection are the same thing. And so if the failure to file an objection, it says, the decision is not subject to judicial review except for the purpose of questioning the jurisdiction of the administrative agency over the person or subject matter. The Legacy Foundation Action Fund has been trying over and over again to get a court to rule on the merits of whether this Citizen Clean Elections Commission can expand its jurisdiction into deciding whether something is an independent expenditure or not. We filed in July of 2014. We filed a special action that was dismissed, and it was dismissed because of failure to exhaust administrative remedies. We went through that process. We filed another special action after the dismissal here. That was also dismissed. Then we have the dismissal of this case on the procedural grounds under 16957.
Let's go back to my earlier question. So from your perspective, you could have waited a year. You didn't have to go under any particular time frame for filing an appeal. You could have waited 2 years from now and filed a challenge saying the Clean Elections Commission acted outside their authority.
Or we could have collaterally attacked the judgment if they had tried to take an enforcement action for their monetary judgment.
It's clear that if the trial court's ruling had simply been a legal question, it came out adverse to you. If you'd failed to file a timely notice of appeal, you'd be out of luck, right? That's only the first half of the question.
Okay.
So assuming that's correct, that if you simply disagree with the trial court's ruling or an instruction given in the trial court and you lose on that and you fail to timely appeal, your case is over, right?
That's true. So
is the difference in your mind in this case your legal theory of appeal?
Well, no. I think because a void judgment is void no matter whether no matter what other
judgment void when it's a judgment that a trial court judge enters after hearing a case. Because
it never got to the merits. It dismissed pursuant to 957 to 16-957B, and 16-957B is an interesting statute when you consider the overlay of the agency's own administrative regulations here, and this is where this case, frankly, gets very confusing. If you look at the conclusion of the administrative order that was issued on, or the order that was issued on November 28, 2014, at the conclusion of the order, the agency calls it cites 41-1092.08 sub F, and says what they were doing was, if you read the conclusion, the Commission rejects the decision's recommended order, this was the decision of the administrative law judge, and affirms the Commission's November 28th order and civil penalties of $95,460. So it's really unclear as to if 957B actually applied to this order at all. The order assessing civil penalties was actually issued in November of 2014. And then we grafted on top of that were the agency's own administrative procedures, which we then followed, had our hearing before the administrative law judge. And then there was this other order that didn't purport to be an order assessing civil penalties. It's an order affirming an order assessing civil penalties. And under that theory, it's very unclear as to exactly which timeline applied. But no matter what, when you're challenging jurisdiction under the Judicial Review of Administrative Decisions Act, when you're challenging jurisdiction, those timeframes don't apply.
Can I go back to 12902B?
Sure.
It says the administrative decision becomes final. There's an exception if the administrative decision becomes final because of a failure to file any document in the nature of an objection, protest, petition for hearing, or application for administrative review. That sounds to me like if you've defaulted before the administrative agency. Am I misreading that?
Yeah, I think you need to read objection separate from protest, separate from what follows after the comma, petition for hearing or administrative or application for administrative review. In other words, you don't take the phrase administrative review and apply it backwards. I think what the second sentence...
Objection, protest, petition for hearing, or application for administrative review. Isn't it an objection to administrative review? So you're reading that as just an objection at any point along the way, including at the time of appeal?
Right. And so I think what 12902B is acknowledging is what the Supreme Court said in Wells and what was recognized in Arcules by Division 2 of this court and what was recognized by Pawn 1 by this division of this court, which is...
That Arcules the statement is dictum in that case?
Your Honor, we don't believe that it is. It was clearly an analysis of how 12902B applies.
Doesn't 902 applies to parties, does it not?
902 does apply to parties.
And Arcules was someone who was not a party to the proceeding below. That's my recollection anyway.
That's true, but this court applied Arcules in the Pier 1 case and found that judgments that were void no matter what. And in that case, I believe it was a party to the appeal or a party to the matter that challenged the decision there of as void ab initio. And this court accepted and followed Arcules and granted and dismissed the claim because it found that the agency had exceeded its authority. This question is about whether the fundamental jurisdictional question here is whether the Clean Elections Commission can mission creep into areas that it really doesn't have jurisdiction over. And an agency that exceeds its jurisdiction can't, just because of a lapse of time or some other issue by a party, let that go. And I also point the court to...
But I guess just going back to kind of, and this may just demonstrate my lack of knowledge of the procedures, what in your view puts any kind of restriction on getting the parties to get a final resolution? You seem to be suggesting that you can go through the administrative process, participate as a party, but then not take any kind of an appeal, whether within 14 days, whether within 35 days. Don't we want some finality to that judgment? Why shouldn't we have some kind of rule saying you need to appeal that ruling?
Because when you're challenging the jurisdiction of an agency, the court, and there was a series of decisions that we cited, even when things were challenged 2 years later, the courts have accepted challenges to jurisdiction and reviewed them, even when they were filed 2 years after a judgment.
Isn't that if no court has previously reviewed that issue, the issue hasn't been raised in any proceeding? It seems different to me if you've raised it in a proceeding and you've lost in that proceeding. At that point, it seems like you need to appeal from that ruling.
Well, actually, no, because the agency didn't, because the court declined to consider our argument with respect to 902B under 12-902B as to whether the agency even had jurisdiction there. Now, I also want to point the court back to two other things that were critical in our briefing. One, with respect to the rule of court, with respect to the 5-day rule in Rule 6, giving us the 5 additional days. If that rule applies, then we're here. And I point the court to the administrative procedures admitted here. I know that 957B or 16957B says issuance, but the Commission's own regulations provide that they serve it. Well, when you serve something, that seems to imply that Rule 6 applies and gives you the 5 additional days. So even if the court doesn't like our arguments with respect to the notion that jurisdiction could be challenged at any time regardless of anything else, the 5-day rule still clearly applies here because this was a decision that was served. When a decision is served, you get the 5 days. If you go with just the vague phrase issuance.
Even if there's a statute, though, that says jurisdiction is determined based on the date of issuance?
But what does issuance mean? I mean, if
There's issuance and then there's service. You're not necessarily disagreeing when the decision was issued, are you?
Well, I mean, the decision has a date on it. And I mean, it says done this date of 27th of March, 2015, and they included a certificate of service on that.
But I guess my question, let's say that there was no practice of serving the decision, and there's just an assumption that everybody is present, and the jurisdictional statute says that you have 10 days or 14 days from the date of issuance, and there's simply no service. Is there an argument that there's a question about what the date of issuance is and what the jurisdictional statute for an appeal would mean in that circumstance?
Well, I mean, it's odd where you have a regulation that you have to follow to go through the administrative law judge process before you can get to the final thing. The administrative rules essentially require service, and then to say, oh, service is required there, but the benefits that you get when something is served don't apply on the other end doesn't make a lot of sense. And the Supreme Court never had the opportunity to address that in Smith. So we think that is also even if the court doesn't like any of our other arguments, the 5-day rule is still important and puts us clearly within the 14 days plus the additional 5 days you get with respect to Rule 6. And with that, I think I'd like to reserve the balance of my time for rebuttal.
Just one quick one before you go out the
Sure.
door. 957B says you have 14 days to appeal from the issuance of an order to appeal to the Superior Court. Your argument seems to be this wasn't the issuance of an initial order. This was a confirmation of an earlier order.
Well, part of the problem here is it's not really clear what this was. You know, they say this is a final administrative decision pursuant to ARS 41-10.92.08 sub F. But now they're claiming, no, this was actually an order assessing civil penalties pursuant to 16-957, but what it actually says is this is an affirmation of an order from November 28th, 2014, which they call an order and civil penalties of $95,000. So part of the problem here, and if you read Smith carefully in footnote 4, the Supreme Court actually cautioned the Commission about this exact problem, which is they've got a statute, then they grafted on top of that a regulation that sends you into a whole other area of the code, and then they come back and try to claim, no, that other part of the code actually applies. And again, we're back for a second time over something that the court cautioned the Commission over.
You're right that the Commission sometimes uses some sloppy language, but wasn't the gist of Smith that you have 14 days to appeal that initial order and any subsequent decision confirming a penalty under the Act?
Well, I think the other thing that distinguishes our situation from Smith is that in our case, we actually prevailed before the administrative law judge. Then they reversed the administrative law judge, and then they backwards affirmed the order that they had issued before we were even in front of the administrative law judge. So I think that adds to the lack of clarity of the procedural situation that we found ourselves in. And with that, I'd like to reserve the balance of my time.
Good afternoon, Your Honors, and may it please the Court. I'm Joseph Roth with Mary O'Grady on behalf of the appellee, the Clean Elections Commission. I want to start with something that was said that the focus here was a commitment that there's an unbound and limitless extension of time to challenge jurisdiction in this matter. I want to make clear that the Commission has never disputed that LFAF, as I'll call them, or any other party subject to an enforcement proceeding before the Commission could challenge jurisdiction. That's not the question. The question here is whether that challenge is brought in a timely manner. Here, LFAF's complaint for judicial review was not timely. There's no objection to that here. I didn't hear any suggestion that the 14-day deadline wouldn't apply if the order, the March 27 order, is the final administrative decision of the Clean Election Commission. So the question for the Court today is really a rather simple and narrow one. Was the 14-day deadline applicable? Was it jurisdictional? And did LFAF fail to meet it? The answer to all three of those questions is yes. And so the result is that the case should be dismissed, just as the Superior Court did. Because the deadline, the 14-day deadline, is a jurisdictional deadline, the consequence is that the Superior Court and this Court lack jurisdiction to consider the appeal, including a jurisdictional challenge. There was a full right and ability to bring the jurisdictional argument and the range of arguments that were briefed in part of the complaint, the late complaint for judicial relief. It simply was untimely, and the right to appeal was lost, but it was present, it was adequate. A separate collateral special action couldn't be brought because the question there is the right to appeal equally adequate, equally speedy? Here, there was a right to appeal. That's the key question. Whether it was lost through inadvertence or whatever the cause does not change the outcome.
What's your response to the argument that by adopting regulations saying the decision will be mailed, there's a provision for mailing, why that doesn't provide an additional 5 days?
Well, when you're on the statute, doesn't say that. The statute says that issuance, 16957B says that the appeal should come within 14 days from issuance of the order. I don't think there's any doubt between the meaning, and I didn't hear any, but the doubt between the meaning of issuance and service. The fact that the Commission, through its rules, provides for additional surety of notice and requires service in case maybe not all members of the party were present at the proceedings, which was not the case here. Everyone was there. The fact that the rules provide for that additional notice, that additional amount of due process, should not change the rules, and more importantly, could not change the rules. Even if the Commission completely screwed up the wording in that nature, or the rules somehow affected that, the Commission has no authority to waive a jurisdictional deadline that is set by statute in 16957B. So I think that the mailing rule, extra days under Rule 6, simply is not applicable. And the briefing, the argument depended on a confluence of the meaning of issuance and service, and it seems as though that no longer is the prevailing argument. But I don't think there's any lack of clarity, and the cases don't demonstrate any lack of clarity between the difference of those two. The courts that have addressed it have quite clearly said that issuance means the date the order is entered, and services has to do with delivering it. So I don't think that there's any real colorable argument to say that you can graft on the Civil Rule 6E extra days, change that here. And the same was true in Smith. In paragraphs 30 to 32, I believe, in Smith, the court calculated what the deadlines were there, and they calculated 14 days from issuance of the order. There was no additional days, no reference to the civil rules. It was straight 2 weeks. But
that issue didn't raise its head there.
That's correct. That's correct, Your Honor. I want to address the arguments that were made about 12902B, as that seems to be a central focus here, as to whether 902B could create some kind of exemption for jurisdictional challenges. A very straightforward reading of the statute shows that really there are two sentences in 902B. But first, you should start at 902A. 12902A says, what is the scope of this article that's about judicial review of final administrative decisions? 902A says, this act shall apply to the review of final administrative decisions. Then you move to 902B, which provides two separate constraints on the ability to appeal. So they graphed on a wide expansion out of the second sentence, but really those two sentences in 902B provide two very different constraints on appeal. The first sentence is an outright constraint on the ability to appeal. That is the jurisdictional timeline we are talking about here today. Unless a timely appeal is followed, judicial review shall be barred. The second sentence is a constraint on what issues could be brought in an appeal. It says if the decision becomes final, I won't go through the language because we went through it before, but if the decision becomes final because of a failure to file an objection, something of that order, then the appeal is limited to questions of jurisdiction. The interpretation advanced by LFAF really does not make logical sense because the contention there is that a notice of appeal, or here the complaint for judicial review, is within that series of documents that if the decision becomes final, that could be one of them. And that really makes no sense because you could not file and would not file a notice of appeal or a complaint for judicial review from a non-final administrative decision that only follows a final administrative decision. So it doesn't make any logical sense to say that a notice of appeal fits within that category of documents. There is no appeal available until you have that final administrative decision. I want to be sure to also address Smith, because Smith really resolves most of the arguments in this case, including what if the order is a little bit unclear? What about the fact that the commission requires the exhaustion of additional administrative remedies, the administrative appeal process before a final administrative decision will follow from that initial order assessing penalties? Well, what Smith said is the fact that there are additional administrative remedies sought by the parties does not nullify the 14-day deadline in 16957B. All it does is delay the entry of a final administrative decision. So to turn to that, LFAF's argument has made some contention that the order is unclear. The March 27 order is not unclear. What it says is that the penalty is affirmed, and this order is a final administrative decision. What that does is it tells you that this is an order subject to 957B, and it is an order that you can appeal. You have a right to appeal. 957B tells you that appeal to the Superior Court must occur within 14 days, and it also cites the Judicial Review of Administrative Decisions Act, which is where 902B is. Again, it's a reference to the fact that because you now have that final administrative decision, you may appeal it. And the deadline for that is found in 957B. Smith confirms that that deadline is applicable to final commission decisions, and it is a jurisdictional deadline that cannot be waived by the commission and cannot be waived by the court.
Can you shed some light on why that March 27th order says it was pursuant to 41-1092 and not 16957B?
Yes, thank you, Judge Birch. What that is, if you look at that statute, what it says is final administrative decisions may be appealed pursuant to Girata. So it really is a duplicative reference to the same thing 957B says. Appeals to the Superior Court may be had pursuant to Girata. If you go to Girata, as I've said, under 902A, that tells us we can appeal if you have a final administrative decision. So really it's a reference to confirm under the Uniform Hearings Administrative Procedure Act. I may be messing that name up a little bit. Under Title 41, it is saying under those uniform rules, this is a final administrative decision. Look to your appeal rights in the courts of the state.
Aren't there much clearer ways to say that this is a final order, and you should maybe look to 16957B for a time limit?
That very well may be that in retrospect, if we had it spelled out in that way, that it would be even clearer, although I'd submit that for the reason I just said, that if you have an order assessing a penalty that is final, 957B is there. You have an Arizona Supreme Court case telling you what the deadline is in such a circumstance when you have an order assessing a penalty. So I'm not sure there's really unfairness from that purported lack of clarity. But the real point for the court here today is that were that the case, the Commission's muddiness in its order language cannot waive the jurisdictional deadline. It doesn't change it. It doesn't change the consequence of failing to meet the jurisdictional deadline.
Could I ask, in your view, is there any avenue open for any type of collateral review?
At this point, Judge Catani, no, I do not believe that's the case, because the question on a collateral review, which would probably come via a petition for special action or complaint for special action, the first question that the court must ask in deciding whether it can issue that relief is there an equally adequate remedy by appeal? And the answer here is yes. And there is law that is citing in our briefing below that stands for the proposition that basically if you have the right to appeal, fail to pursue it, the answer to the question is still yes, there was an adequate remedy by appeal. The failure to take advantage of it does not change the answer to that question. There could be collateral review, for example, if at the outset of the case or at some point a party like LFAF or subject to proceedings said, I'm not participating at all. You have no jurisdiction. That's the only argument I'm going to raise. I can bring a special action. I think there's a basis in law to bring that before you participate in the process and subject yourself to the statute of the Girata Act, which establishes a notice of appeal. I'm sorry, go ahead, Judge.
What if there's new evidence that the Commission only acts when someone challenges someone of one particular party? Would that be, I guess, a new action as opposed to a collateral action? Would something like that be precluded if there's new evidence that the Commission has singled out Democrats or has singled out Republicans?
I would say it's hard to venture into that much of a hypothetical, but I could imagine that there could possibly be some sort of claim under a Rule 60 type claim where you have new evidence and there's strictures on what kinds of new evidence matters in that circumstance when you can go back and open up a dormant case. But what's clear here is we have an issue that was raised from the beginning and a right to appeal it and a full ability to bring it to the Superior Court and then to this court that was simply missed for whatever reason. And the court is at that point deprived of jurisdiction to consider that issue. Whether there could be a scenario where a new set of a new reality would come into play that would alter those past facts. I guess I would have to assess it on the fact. It's really hard to say, although I can imagine a scenario where strong evidence of fraud meeting the Rule 60 standards, those strict standards could conceivably be raised in a new action. I don't think it would be collateral action of the like that's been advanced here, where there's a limitless, open-ended time to file a jurisdictional challenge. Smith also rejected that concept. Smith quite clearly said that finality is in and of itself a value. There should be a date on which administrative decisions become final, and it should be identifiable, is what Smith says. And that applies here, and here it would be identifiable. Under LFAF's position that we've heard, there's a commitment to the position that it could be a year, it could be 2 years, and notwithstanding participation as a party before the proceeding, notwithstanding the language of 902.
And why not the 35-day deadline? It does seem like it's an appeal of an administrative decision, and the general provisions say 35 days. Why would that be an unreasonable position to take?
It wouldn't be unreasonable if the statute didn't provide otherwise, and if Smith already hadn't rejected that argument. As Smith held, the Gerard, I believe it's in 902. Give me one moment. I believe it's in 902A, 12902A. The article applies unless the act creating or conferring power on an agency or a separate act provides for judicial review and prescribes a definite procedure for the review. And as Smith held, here 16957B provides that more definite procedure in terms of the timeline. And in order to reach the result that your question presupposes, Smith would have to be overruled on that point. There was some. I'd be remiss not to address the question. The narrow question is jurisdiction here is the questions that have been advanced really go well beyond what kind of jurisdiction. Even the cases that say subject matter jurisdiction can always be brought, or a judgment void for lack of jurisdiction can be challenged. The kinds of arguments raised here as to whether the speech qualifies or the parties qualify as applied and under the facts of this case is not the kind of questions even that would be preserved even under were LFAF's argument correct. Here the question is, could the commission adjudicate the alleged violation of 16941D, a failure to report an independent expenditure? The answer is very clearly yes. The Clean Elections Act in 16956A7 says that the Clean Elections Commission is empowered to enforce this article and empowered to enforce the act. And 16941D is one part of that act. And that the allegation in this case was that there was a failure to report pursuant to 941D. So many of the arguments go well beyond that scope of jurisdiction. But in any event, those arguments could have all been advanced were a timely appeal sought, and one was not sought here. I want to address the Arcules case that was discussed, and there were some questions about it. It is, I think, quite clearly dicta, as we state in our briefs, and there's a separate reason that is not in the briefs, if you look at the case, why it's also irrelevant. The citation to 902B in Arcules is also irrelevant, and that is because the scenario there not only involved a non-party bringing a complaint for special action, but there the court likened the statutory authority to file that special action to a statute of limitations for that non-party. And statute of limitations are not jurisdictional. So you do not have, so whatever the language or the broad language citing 902B in Arcules meant or could mean, it certainly has no application to a situation where a party fails to meet a jurisdictional appellate deadline. The case, the Pawn 1 case, was the exact same. The Pawn 1st case that was filed yesterday as a supplemental authority that Mr. Turchinsky referenced is in the same procedural posture. It was the same type of action filed by a non-party who was aggrieved by the zoning decision made as to some other piece of property. So there, that distinction is very vital, because here the question is, was a jurisdictional deadline missed, not just was a deadline that could be equitably told missed. And I think that is why, Judge Birch's, the answer to your question, whether the alleged sloppiness in the order matters, it doesn't matter or can't matter. I'm happy to discuss any of the other arguments in the briefing or any other questions that Your Honors have, but I think that the case really is quite simple as to whether a jurisdictional deadline was missed, and it was. Thank you, Your Honors.
As I have a couple of brief points on rebuttal. Judge Catani, you asked whether filing 2 years late after a final judgment could be attacked as void was permissible, and I point you to what the Arizona Supreme Court said in Wells. And this actually, in the case called Wells, the case is actually Wells v. Valley National Bank. It's 19 ARIZ 345. And at page 347, the Supreme Court said, moreover, although it was more than 2 years since the final judgment, it has always been held that the mere lapse of time is no bar to an attack on a void judgment. And what we're saying here is this is a void judgment because because the Clean Elections Commission didn't have either subject matter jurisdiction or personal jurisdiction over Legacy Foundation Action Fund. So we could have, even if we had waited 2 years, attacked this judgment as void under Wells and its progeny, because there's a lot of other Supreme Court cases since then and appeals court cases since then that have cited to Wells for this specific proposition. And there's nothing even though Arcules was involved in non-party, it cited 902B. 902B really only applies to parties and explained that there is an exception to challenges when you're challenging the subject matter or personal jurisdiction of the administrative agency. And for that reason, we think that while they try to distinguish Arcules and say, oh, well, because it applies somehow differently to a non-party, the decision itself didn't make that distinction when it was analyzing 902B. It cited 902B, the second sentence, for the broad proposition that these deadlines don't apply when you're challenging the jurisdiction of the agency.
But why isn't there a difference, though, when it's a party? Because a party that has raised the issue seems to be in a very different position than a non-party who's never come in with an argument regarding authority of the agency to act.
Because the Supreme Court told us that in Wells. The Supreme Court told us that when you're attacking a void judgment, the mere lapse of time does not bar an attack on a void judgment.
And that involved parties who participated. We'll look through it.
Yeah, Wells involved a default judgment, actually, that had become final.
Doesn't that go to kind of the reference in 902? If a judgment has become final because of the failure to file something or my interpretation of a default, then that would be an exception. That seems different than if the actual issue has been raised and a final decision has been made regarding authority to act. It seems different than a default.
Again, I would point you to what the Supreme Court held in Wells, even though it seems illogical to a court and judges that there's some challenges that could be brought after certain deadlines. In this particular case, this is an exception when you're challenging the scope of an agency's jurisdiction. So, thank you, Your Honors.
Thank you. Thank you both for your argument, for your briefing. We'll take this matter under advisement and issue a decision in due course. And with that, we're adjourned.